Chapter 2 Consideration. Section 24. Presumption of Consideration. Every negotiable instrument is deemed prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. Meaning of consideration in general. Consideration means an inducement to a contract, that is, the cause, price or impelling influence which induces a contracting party to enter into the contract. It is the essential or more proximate purpose a party has in view at the time of entering into the contract. It is different from motive, which is the personal or private reasons of a party in entering into a contract. Presumption of consideration. Like all other contracts, a negotiable instrument must have a consideration or cause. It is not necessary, however, that the consideration be expressly stated in the instrument. The presumption is that it has been issued for a valuable consideration and that every person whose signature appears thereon has become a party thereto for value, whether the words value received appear in it or not. Consideration being presumed, it need not be alleged and proved. But the presumption is only prima facie. It may, therefore, be rebutted by evidence to the contrary. The evidence must be convincing to overthrow the presumption. It is not overcome by a mere denial of receipt of the consideration. Example. Am issued in favor of P a promissory note which recites, 30 days after date, I promise to pay P or order the amount of 1,000 pesos, signed M. On the back of the note the following endorsement appears. Pay to A, signed P. Although the promissory note does not mention the consideration, the law presumes that M must have received a consideration for the note and that the same is lawful. If M claims otherwise, then, he has the burden to rebut the presumption. Similarly, it is presumed that P, as an endorser, received some valuable consideration from A. A need not prove that he paid for the note. If P claims otherwise, he must prove his allegation. Section 25. Value. What constitutes? Value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt constitutes value, and is deemed such whether the instrument is payable on demand or at a future time. Valuable consideration in general. 1. Value means valuable consideration. Section 191. 2. Valuable consideration may in general terms be said to consist either in some right, interest, profit or benefit accruing to the party who makes the contract, or some forbearance, detriment, loss, responsibility, act, labor or service, on the other side. And if any of these exists, it will furnish a sufficient consideration to sustain the making or endorsing of a promissory note in favor of the payee or other holder. It is no defense to an action on a promissory note for the maker to say that there was no consideration which was beneficial to him personally. It is sufficient if the consideration was a benefit conferred upon a third person or a detriment suffered by the promisee, at the instance of the promisor. It is enough that the obligee forgoes some right or privilege, or suffers some detriment. But a check issued to a person who was not authorized to collect and receive the same is without valuable consideration and is also considered issued for a non-existing account. 3. Simply defined, consideration means any prestation sufficient to support any contract in favor of the party to an instrument, such as the maker or endorser, and it may consist in giving, doing, or not doing. Therefore, a consideration, founded on mere love, affection, or gratitude is not sufficient to sustain an action on a note or bill, as for example, when an instrument is made or accepted by a parent in favor of a child, the same cannot be enforced as between the original parties. In an exchange of notes or bills, each note or bill is a good consideration for the other. A valuable consideration need not be adequate. It is sufficient if it is a valuable one. Example. Where P sells and delivers to M a piano worth 9,000 pesos and M issues to P a promissory note for 10,000 pesos, there is a valuable consideration for the note, which is the piano. In an action on the note, M cannot allege as a defense that the value of the piano is not adequate for the amount of the note. The law presumes that M is capable of managing his affairs, and the mere inadequacy of the consideration is not a sufficient ground for relief unless there is fraud, mistake, or undue influence. Antecedent or pre-existing debt. An antecedent or pre-existing debt is a valuable consideration. The debt may be that of a third person, and the discharge of such debt is a valuable consideration for a negotiable instrument, whether such instrument is payable on demand or at a future time. It must be shown that the holder has given up the pre-existing debt or the right to sue. The transfer of negotiable instruments not only as security for new purchases and advances, made upon the transfer thereof, but also as security for antecedent debts has become very common in the commercial world. Such transactions contribute largely to the benefit and convenience both of debtors and creditors. The creditor is thereby enabled to realize or to secure his debt, and thus may safely give a prolonged credit, or forbear from taking any legal steps to enforce his rights. The debtor has also the advantage of making his negotiable paper of equivalent value to cash. Were the rule otherwise, that negotiable papers cannot be applied in payment of, or as a security for pre-existing debts, without letting in all the defenses between the original and antecedent parties, the value and circulation of such securities must be essentially diminished, and the debtor driven to the embarrassment of making a sale thereof, often at a ruinous discount, to some third person, and then by circuity to apply the proceeds to the payment of his debts. Examples. 1. M owes 1,000 pesos payable today. M fails to pay in cash. He issues a check for that amount to P, who accepts the check. Here, the consideration for the check is the pre-existing debt of M. 2. If X is the debtor and he fails to pay P the amount of 1,000 pesos, the check issued by M in favor of P for the benefit of X rests on a sufficient consideration, that is, the pre-existing debt of X. Section 26. What constitutes holder for value? Where value has at any time been given for the instrument, the holder is deemed a holder for value in respect to all parties who become such prior to that time. What constitutes a holder for value? A holder for value is one who has given a valuable consideration for the instrument issued or negotiated to him. The holder is deemed as such not only as regards the party to whom value has been given by him, but also in respect to all those who became parties prior to the time when value was given. A holder of a negotiable instrument is presumed to be a holder for value until the contrary is shown. A holder who has not given value for an instrument obviously will suffer no loss by being unable to recover from the primary party in the event that the latter has a personal defense assertable by him. Examples. 1. M issues a note to P, the payee, without consideration. P, also without consideration, endorses it to A who, with value, endorses it to B. Under Section 26, B is deemed a holder for value not only as regards A but also as regards M and P. If B is a holder in due course, Section 52, he may enforce payment for the full amount of the note against M, P and A. Section 57, if B is not a holder in due course, M can set up the defense of absence of consideration. Section 58. 2. Now suppose in the same example, B negotiates the note to C by way of a gift. C is a holder for value within the meaning of Section 26 as against M, P, and A because they became parties prior to the time when value was given on the note by B. 3. P is the payee of a check drawn by R against E Bank. He deposits the check with W Bank, his bank, which credits the amount thereof to his account. Is W Bank a holder for value under Sections 25 and 26? No, because W has parted with nothing and crediting the amount involves a mere bookkeeping entry. It does not constitute the giving of value. Therefore, E is not entitled to recover from R assuming that R has a personal defense against C. However, if P, after depositing the check, withdrew from his account to such an extent that the particular credited item was exhausted, E is a holder for value. If the sum had subsequently been checked out, then value would have passed. But how shall one determine whether or not the funds represented by the particular check have been withdrawn where there has been a continuous flow of deposits and drawings by the depositor? Under the rule, that the first money in is the first money out, the first debits are to be charged against the first credits. A different rule states that as long as the balance of the depositor of P is equal to or exceeds the amount of the check paid, said balance cannot be considered as withdrawn and, therefore, W. Bank, at this stage, is not a holder for value. The second is the better rule. Under our law, bank deposits are governed by the provisions on simple loan. Article 1980, Civil Code, as creditor, the depositor does not expect to receive the identical money in return but an equivalent sum. His money becomes the money of the bank and is mingled with the other money, the entire amount forming a single fund from which all deposits are paid. Section 27. When hen on instrument constitutes holder for value. Where the holder has a lien on the instrument, arising either from contract or by implication of law, he is deemed a holder for value to the extent of his lien. Where a holder has lien on instrument. One who has taken a negotiable instrument as collateral security for a debt has a lien on the instrument. As such holder of collateral security, he would be a pledgee but the requirements therefor and the effects thereof, not being provided for by the negotiable instruments law, shall be governed by the provisions of the Civil Code on pledge of incorporeal rights. If the amount of the instrument is more than the debt secured by such instrument, the pledgee is a holder for value to the extent of his lien. He can collect the full value of the instrument, and apply the same to the payment of the debt but he must deliver the surplus to the pledger. If, between the pledger and the party liable on the instrument, there are existing defenses, then pledgee can collect on the instrument only to the extent of the amount of the debt. If the amount of the instrument is less than or the same as the debt secured by such instrument, the pledgee is a holder for value for the full amount and may, therefore, recover all. If the defenses of the party liable on the instrument are real defenses, then the pledgee can recover nothing upon the instrument. Examples. 1. M makes a promissory note for 1,000 pesos to the order of P who pledges it to A to secure the payment of P's debt of 800 pesos. The note is endorsed and delivered by P to A. Article 2095. Incorporeal rights, evidenced by negotiable instruments, bills of lading, shares of stock, bonds, warehouse receipts and similar documents may also be pledged. The instrument proving the right pledged shall be delivered to the creditor, and if negotiable, must be endorsed. Article 2096. A pledge shall not take effect against third persons if a description of the thing pledged and the date of the pledge do not appear. In this case, A is a holder for value to the extent of 800 pesos which is also the extent of his lien. On the maturity of the note, even if the debt of 800 pesos is not yet due, A may recover the full amount of 1,000 pesos, holding the surplus for P, the pledger. 2. If M has defenses against P, endorser, such as absence or failure of consideration, Section 28, A can collect on 800 pesos on the note even if he is a holder in due course. As the note in the hands of M is void, all that ought to be recovered by A is the amount due on the loan. 3. Supposing that the amount of the instrument is 700 pesos. Then A is a holder for value for the full amount of 700 pesos. And is entitled to recover to that extent. 4. If the signature of M is a forgery, A can collect nothing from M because M's signature is inoperative. As against M, A acquired no right to enforce payment of the note. Section 23, Forgery is a real defense. Section 28. Effect of want of consideration. Absence or failure of consideration is a matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Meaning of absence or want of consideration. Absence of consideration means a total lack of any valid consideration for the contract, in consequence of which the alleged contract must fall. Example. M makes a promissory note to P in payment for a parcel of land which does not exist. As between the parties, there can be no recovery on the note as there is absence of consideration. But if P endorses the note to a holder in due course, A can recover from M because absence of consideration is only a personal defense not available against a holder in due course. Meaning of failure of consideration. Failure of consideration means the failure or refusal of one of the parties to do, perform or comply with the consideration agreed upon. In other words, something was agreed upon as consideration but for some cause, such agreed consideration failed to materialize. Examples. 1. In the example given, if there is really a land owned by P which was sold, but P failed to deliver it to M because he sold it again to X who in good faith registered the sale, there is a failure of consideration so that P cannot recover from M. If only 2/3 portion of the land was delivered, there would be a partial failure of consideration which would bar recovery only pro tanto. Hence, P could recover only 2/3 of the note as M is not liable to the extent of 1/3 which is the price of the undelivered portion. 2. R issued a check in the name of P under an agreement that the amount of the check was to be given to X in payment of textiles and that profits to be derived from the investment was to be divided equally between R and P. P endorsed and cashed the check and turned over the proceeds to X. The latter, however, failed to deliver the textiles to R. The account was carried in R's books as P's indebtedness and notice thereof was given to him every year for his confirmation. In view of this, the claim of P that he signed the check only as a witness and that the long period of time that elapsed before the suit was filed created a presumption against his liability was held untenable. Hence, R could recover from P the face value of the check. Section 29. Liability of accommodation party. An accommodation party is one who has signed the instrument as maker, drawer, acceptor, or endorser, without receiving value therefor, and for the purpose of lending his name to some other person. Such a person is liable on the instrument to a holder for value, notwithstanding such holder at the time of taking the instrument knew him to be only an accommodation party. Definition of terms. 1. Accommodation bill or note is one to which the accommodation party has put his name, without consideration, for the purpose of accommodating some other party who is to use it, and is expected to pay it. In other words, it is a loan of one's credit. An accommodation paper creates no obligation upon delivery to the accommodated party and is of no legal efficacy and creates no obligation until delivered or negotiated to a holder for value. 2. Accommodation party is one who has signed the instrument, a. as maker, drawer, acceptor, or endorser, b. without receiving value for the signature and c. for the purpose of lending his name to some other person. Section 29. He usually expects that not he, but the accommodated party, will provide payment of the bill or note when it falls due. He actually lends his credit to the party to whom the accommodation is made. He is classified according to the accommodated party's status. If the accommodated party is a maker, for example, he is liable on the instrument to subsequent parties as if he were the maker. In lending his name to the accommodated party, the accommodation party is, in effect, a surety for the former. 3. Accommodated party is one in whose favor a person, without receiving value therefor, signs an instrument for the purpose of lending his credit and enabling said party to raise money upon it. Section 29. He impliedly agrees to take up the instrument at maturity and to indemnify the accommodation party against the consequences of non-payment. Example. P is in immediate need of 30,000 pesos but he cannot find anybody to lend him the sum he needs. No one trusts him because he has no credit. He goes to M, a rich relative, who is willing to accommodate him by letting him borrow on his, M's, credit. So M signs a promissory note payable to P, receiving no consideration therefor. P then endorses the note to the PNB bank, which discounts the note because of M's credit. In this case, the promissory note is an accommodation note, and P is the accommodated party. P cannot enforce the note against M should P pay PNB because P gave no consideration to M and he was merely accommodated by M. M may simply sign the promissory note payable to PNB to accommodate P in order that P can borrow from PNB. Parole evidence to prove accommodation. The trouble with an accommodation paper lies in the fact that it is impossible to tell from an inspection of the instrument whether the signature was placed on the instrument for accommodation or otherwise. The accommodation party, however, is permitted to show by parole evidence which party he accommodated. If this were not so, an accommodated party could enforce payment of the instrument against the accommodation party. In the absence of concrete evidence showing when one issued the subject check and in what capacity, it cannot be assumed that he intended to lend his name as an accommodation party. Liability of accommodation party to a holder. 1. Absence of consideration not a defense. Section 29, by clear mandate makes the accommodation party liable on the instrument to a holder for value notwithstanding such holder at the time of taking the instrument knew him, the signatory, to be only an accommodation party/7 in whatever capacity he signed the instrument, whether primarily or secondarily. This means that absence of consideration between the accommodation party and the accommodated party does not of itself constitute a valid defense against a holder for value even though he knew of it when he became a holder. 2. Accommodation party in effect a surety. In lending his name to an accommodated party, the accommodation party is, in effect, a surety. However, unlike in a contract of suretyship, the liability of the accommodation party remains not only primary but also unconditional to a holder for value such that even if the accommodated party receives an extension of the period for payment without the consent of the accommodation party, the latter is still liable for the whole obligation and such extension does not release him because as far as a holder for value is concerned, he is a solidary co-debtor. It will then be noted that Section 29 is an exception to Section 28. But Section 29 should not be construed as to allow a holder for value, not otherwise a holder in due course, to recover against an accommodation party in the light of other sections of the negotiable instruments law. In other words, except the defense of absence of consideration between the accommodation party and the accommodated party, the accommodation party is liable to a holder in due course. 3. Rule not applicable to corporations. Section 29 does not include nor apply to corporations which are accommodation parties. This is because the issue or endorsement of negotiable paper by a corporation without consideration and for the accommodation of another is ultra vires. The fact that for lack of capacity the corporation is not bound by an accommodation paper does not thereby absolve, but should render personally liable the signatories of said instrument where the facts show that the accommodation involved was for their personal account, undertaking or purpose and the creditor was aware thereof. Example. In the preceding example, the fact that M did not receive any consideration for the note would not be a defense in an action brought against him by PNB. This would still be true even if PNB knew that M's signature was made for P's accommodation. If M were not to be held liable, then the accommodation would not serve any purpose. Suppose, after signing the promissory note, M keeps it in his safe but P steals it. P then endorses the note to PNB which knows that P has stolen the note. In this case, PNB is not a holder in due course because it knows of the lack of delivery in tender sections 16 and 58, M is not liable. Illustrative case. Payee of a promissory note violated deed of assignment without notice to accommodation makers who then claimed release from their obligation. Facts. As accommodation makers, X and Y executed a deed of real estate mortgage on their property and signed a promissory note issued by the CTC company in favor of PNB which extended a loan to CTC. CTC likewise executed a deed of assignment whereby it assigned to PNB all payments to be received by it, CTC, from BPW, Bureau of Public Works, on account of a contract for the construction of a building. PNB knew that X and Y signed as accommodation makers because of a deed of assignment. X and Y were made to believe, and on that belief, entered into the agreement, that no other conditions would alter the terms thereof. This notwithstanding, PNB approved the release by the BPW of 3 payments directly to CTC instead of paying the same to PNB, without notice to X and Y. X and Y now claim that the violation of the deed of assignment released them from their obligation as sureties, and, therefore, the real estate mortgage executed by them should be cancelled. Issue: may PNB be considered a holder for value under Section 29? Held: no. Although as a general rule a payee may be considered a holder in due course, such rule cannot apply with respect to PNB. Not only was PNB an immediate party or in privy to the promissory note, that is, it had dealt directly with X and Y knowing fully well that the latter signed only as accommodation makers, but more importantly, because of their full reliance on the deed of assignment executed by CTC in favor of PNB. In effect, PNB waived payments of the first 3 releases. From the foregoing circumstances, PNB cannot be regarded as having acted in good faith, which is out of the requisites of a holder in due course under Section 52. Thus, X and Y can validly set up their personal defense of release from the real estate mortgage against PNB because of the violation of the deed of assignment. 4. Where instrument vitiated by an illegality of cause. A holder for value under Section 29 may be a payee. There can be no recovery by a payee against an accommodation party on an instrument vitiated by an illegality of cause. Thus, where the principal debtor bought a TV set and as security, executed a chattel mortgage over it, did not pay for it, and even sold the set without the written consent of the seller mortgagee, who accordingly filed an estoppel case against the buyer mortgager, and to settle extrajudicially the criminal case, the mortgager and another accommodation party executed in favor of the mortgagee a promissory note, there can be no recovery against the accommodation party as the promissory note is vitiated by the illegality of the cause. Promise not to prosecute estoppel case, if the promissory note is executed, but the mortgager has an obligation to the mortgagee independently of the promissory note, because for him to escape from the payment of a just obligation will result in unjust enrichment at the expense of another. 5. Liability of solidary accommodation makers. In a case where 3 accommodation makers executed a promissory note jointly and severally in favor of a bank, it has been held that any one of the solidary accommodation makers may be held liable when the principal debtor who received from the bank the full value of the note failed to pay the same. Rights of accommodation party. 1. Right to revoke accommodation. Since a signature for accommodation is gratuitous, it may be revoked or rescinded by cancellation or by notice to those interested at any time before the instrument has been negotiated for value. But once the instrument has been negotiated for value, the accommodation party is liable according to the face of his undertaking, the same as if he were financially interested in the transaction. 2. Right to reimbursement from accommodated party. After making payment to the holder, the accommodation party has a right to obtain reimbursement from the accommodated party. The relation between them is, in effect, that of principal and surety, the accommodation party being the surety. As between the accommodation party and the accommodated party, the latter is expected to pay the instrument directly to the holder. The accommodated party is the real debtor. Hence, the cause of action is not on the instrument but on an implied contract of reimbursement. 3. Right to contribution from other solidary accommodation maker. Where the solidary accommodation maker paid to the bank the balance due on a promissory note, he may seek contribution from the other solidary accommodation makers in the absence of a contrary agreement between them, and subject to the conditions imposed by law. This right springs from an implied promise between the accommodation makers to share equally the burden resulting from the execution of the note. They are joint guarantors of the principal debtor. Meaning of without receiving value therefore. The law uses the words without receiving value therefore as one of the requisites in order that a person may be considered an accommodation party. This does not mean, however, that one cannot be an accommodation party merely because he has received some consideration for the use of his name. The last word therefore refers to the instrument itself and not to the use of the name by way of accommodation. As stated by our Supreme Court, the expression, Without receiving value therefore only means that no value has been received for the negotiable instrument and not without receiving payment for lending his name. Thus, if in the same example, M is given 1,000 pesos in consideration of lending his name but not for the promissory note he signs, M does not lose his status as an accommodation party. Kinds of accommodation party. An accommodation party is one who has signed the instrument as maker, drawer, acceptor, or endorser. Section 29. Examples. 1. Accommodation maker. M, as accommodation party, issues a promissory note payable to P who may then negotiate it to A. 2. Accommodation drawer. M, as accommodation party, signs a bill of exchange with P as payee, and P may endorse the same to A. 3. Accommodation acceptor. M, as accommodation party, accepts a bill drawn on him by P in favor of himself and P may endorse the same to A. 4. Accommodation endorser. M, as accommodation party, simply signs as an endorser in blank, the bill or note made by P in favor of A, before it is delivered to A. Accommodation party and regular party distinguished. The following are the differences. 1. An accommodation party signs an instrument without receiving value therefore, while a regular party signs the instrument for value. Section 24. 2. An accommodation party signs an instrument for the purpose of lending his name to some other person. Section 29, while a regular party does not sign for that purpose. 3. An accommodation party may always show by parole evidence that he is only such, while a regular party cannot disclaim or limit his personal liability as appearing on the instrument by parole evidence. 4. An accommodation party cannot avail of the defense of absence or failure of consideration against a holder not in due course, while a regular party may avail of said defense against a holder not in due course, and 5. An accommodation party, after paying the holder, may sue for reimbursement the accommodated party, although a subsequent party, while a regular party may not sue any subsequent party for reimbursement.